Hi, everyone. Happy Monday morning. I am Carol Williams with Williams Immigration, and welcome to Beyond the Soundbite, where every Monday morning we talk all things hot and what's happening in U.S. immigration. So let's dive right in. Sort of the biggest thing I want to talk about with you all this morning are the DHS regulatory updates. Every so often, we get news from Department of Homeland Security, which includes the Immigration Service, USCIS, and they list for us in the public, and you can all find this online, things that they are thinking about publishing rules and regulations on. So this is always a great way for us to see what is possibly coming down and when, and what the agency is thinking and what they are planning on doing. And I know as outside counsel, it really helps me help kind of guide my clients in the strategies that we choose when we're working together. So the first thing that I want to talk about are we've got plans from the Immigration Service on upcoming regulations regarding the H-1B visa. We all know that is a specialty occupation visa. And we all know that there's a limited number that are issued every year. So we are looking at potentially at redefining how they consider the H-1B employer-employee relationship, what makes that relationship. Probably they will talk about whether or not the immigrant owner of a business can also sponsor themselves for an H-1B. That is what we often think about and look at when we talk about the employer-employee relationship. But of course, we'll see what they come out in this new potential regulation. They've indicated that they are going to reevaluate and look at their on-site visit program, which is done through FDNS, or Fraud Detection and National Security. They're also looking to clarify what we call cap-gap benefits. Those benefits kick in when you have an F1 student who is applying for an H-1B, but their F1 status will naturally expire before the H-1B begins. So right now we call that cap-gap. So we may be getting some regulations that further clarify what benefits those students will be afforded during that time frame. And they have also told us we may be getting regulations that discuss what is redefining what is a material change in an H-1B employee's employment status, their job duties, and when do we need to file an amended petition. Some folks have thought over the years that the guidance that we currently have is a little bit murky. So maybe the Immigration Service will make that just a teeny bit clearer for us. We will see. And when we're also potentially getting regulations on what happens when in your H-1B employee changes work sites. Do we need a new application? When and how do we notify USCIS? So those rules, regulations, potential changes, DHS has indicated we may have a new set of regulations on that by the end of this year, in December 2021. So again, we will see. I, of course, will keep you updated. That's all very big news. More potential regulations on and surrounding premium processing. So we know that the prior White House administration, we had a final rule that was going to open up the types of applications that could be processed via premium processing. So we're now looking at potentially getting regulations as early as September. And I say September because that is indeed next month, on which applications and how and when. So we're looking at opening up premium processing, hopefully for multinational managers and executives who are applying for green cards. Also, our EB2 physicians that are applying for green cards, and our national interest waivers, as well as some employment authorization documents under certain categories, and those we affectionately refer to as our EADs. And also when we have an H or L that is changing their status right now, those H or L Principals are eligible right now for premium processing, but their dependent applications are not. So we are looking at getting regulations, sort of implementing and expanding premium processing for those applications. And as we know, premium processing is 15 calendar days. 15 calendar days for USCIS to process that application and get us something, hopefully an approval notice. So that would be wonderful to see that avenue of processing applications open up for us. Now, the other thing that we are looking at seeing in the form of new regulations is back to the increase in prevailing wage. So nobody wanted to hear it, but I am going to have to tell you because that's what I have pledged to do for you all here and Beyond the Soundbite. It's really kind of dig deep into some of these things that are happening so that you are aware. So we had a prevailing wage regulation, and it was ultimately shot down, and so we no longer have that. It was supposed to take effect November of next year, but federal court shot that down. So Department of Labor is now said to be looking into the comments that it previously received on the previous rule, and they will take those comments and relook at them all over again and use those comments so that they can they can draft and present to us, its stakeholders, a new prevailing wage rule. So folks, that probably means the prevailing wage is going to go up, and it's probably going to go up for H's, H-1Bs, E3s, and the PERM program. So if we thought that we were never going to have wage increases for those programs, we all need to just sort of get our minds right. Those wages are going to go up at some point. So the current White House administration, in conjunction with Department of Homeland Security and in conjunction also with Department of Labor, is looking at the wages. So we can expect at some point for those to go up. The regulatory agenda says that we should be looking at a new rule as early as November of this year. Again, we'll see. We don't know yet, but those wages are at some point going to go up, and we should be preparing our clients for that. Next up on the regulatory list is DACA. We'll see. We'll see if there is a new regulation that is put out. DHS is projecting to have a regulation out as early as this month that would propose DACA as a regulatory ruling versus the executive order that we are currently operating on. The current executive order was signed into law by President Obama, went through a lot of turmoil under the prior White House administration, and now is back under President Biden. So we will see if the current White House administration under President Biden can get DACA officially on the books as a regulation with some sort of permanent relief for current, hopefully, and future DACA recipients. Public charge was also on the regulatory list. We still have a public charge rule. We still have a public charge policy. We still have a public charge obligation to explain to our clients and folks that we work with. We had a very, very, some folks thought, invasive and very restrictive public charge rule published by the prior White House administration. That rule was shot down during litigation. So we are back to our, sort of our old public charge rule, but there is a public charge rule. We are now looking at the current White House administration in conjunction with in conjunction with DHS, reevaluating the comments that were received again on that previous White House administration rule and coming up with a rule of their own on public charge. So we are not sort of out of the public charge woods yet, as it would seem. So that is also on the horizon. We are looking at publication of the advance notice sometime later this month in August. So we'll see if they stay on track for that. Whether they stay on track or not, I will certainly keep you updated on all things public charge. Now, we've also seen some movement on Department of State under their regulatory processes. They are looking at a rule that would limit in-person interviews overseas at the consulates. Part of this is very, very temporary, so I don't want anyone to think that this is going to be a permanent change, but they are looking at doing something very temporary until we are sort of cleared and over the pandemic. So they are looking at waiving in-person interviews for individuals who have recently, as far back as about September of 2018, received a visa. And so that is absolutely not being done right now. They are looking at that. So if they have said that potentially it would be in effect until 180 days after the COVID-19 national emergency has been lifted. So again, that is not in place just quite yet. They are looking at implementing that. But that would be a significant help to their backlog, and it would also help people, be able to obviously get their visas and come into the U.S. and begin working. They are also looking at, under very limited exceptions, which they have not told us what those exceptions are yet, waiving the interview for people that are applying for their green cards at consulates overseas. So lots and lots and lots and lots of new regulations and policies that may be coming down at us. I will certainly keep you updated as we see movement, either forward or backward movement on any of those potentially upcoming regulations, so that we are all in the know. And I have a question from Gabby. Is there any news regarding H4/L2 EAD processing times? She says, dependent work authorization cards are taking a very long time, perhaps a year. You are absolutely correct. Work authorization cards are taking, I've seen really about a minimum processing time of about 10 months, sometimes longer. I don't have any new news, no new updates in terms of the dependent EAD processing times. Unfortunately, Gabby, those are caught up with the generalized backlog of EAD processing. But I will keep that on my list for you. And as soon as I hear anything about that, I will certainly add it to my Monday morning lives. And if I get news on a Wednesday and I'm not going live till Monday, I can certainly shoot you a quick DM so that you are aware of that. And thanks for the question. And thanks for joining me this morning. I appreciate that. All right, folks, so that's what we've got in terms of DHS rules, regulations that we see coming down the pike that they have released in their regulatory agenda for us. We've also got some great news for those individuals that qualify and can benefit from TPS, which is temporary protected status. We have seen the initial registration period extended from 180 days to 18 months. That is huge. That is a huge lead time. So for Venezuela, that means it is now extended into September 9th, 2022. For Syria, that initial registration is extended until September 30th of 2022. And for Burmese citizens, that is extended until November 25th of 2022. So if you are eligible for TPS, or you think you are eligible, you have questions, please feel free to give my office a call at 954-903-1337. And we can certainly help you, walk you through what needs to happen for that. And also, if you have questions on how, these new regulations may potentially impact your hiring of foreign nationals, feel free to drop me a line as well. And we can talk strategy on that. The last thing I want to talk with you all about this morning is something that you may not know about. When you are here as a non-US citizen and you have had dealings with the Immigration Service, you are required to change your address with them, especially if you have an application pending with them. You want to be getting your receipt notices and your biometric notices, and most importantly, you want to be getting your approval notices and your green cards. And you want them to be able to reach out to you. So if you change your home address, you are required to fill out what's called a Form AR11. You can either do that online or you can do it via paper and mail it in. Obviously, online is a little bit quicker for most folks. But we have seen a glitch in that AR-11 online. The Immigration Service is aware of this glitch, that it's not working properly, and people are having difficulty trying to change their address online. Keep trying and keep printouts, because I don't want you to have adverse impact because they said that they couldn't reach you because you did not change your address. So definitely try to do it online. Keep trying to do it online. Keep printouts of what you're doing. If this lasts too much longer, go ahead, print it out, fill it out, and mail it in as well. But keep a copy of what you've mailed in, and also keep a copy of the tracking information, just in case you need to show later on to the service that you did in fact send it in, and they did in fact receive it. So y'all, that is what I got for you this Monday morning. Packed full of information. If you have any questions about what's going on in U.S. immigration, feel free to drop me a line the way that Gabby did here in the comments. I do read them. I do respond. So feel free to drop a comment below, or you can send me a message, or you can even call me at the office. So this is Carol Williams, Williams Immigration. You can reach me at the office at 954-903-1337. And this is another Monday morning edition of Beyond the Soundbite. Have a great morning and a wonderful rest of your week. Goodbye, everybody.